Hello everyone and welcome back. In this video I'm going to talk to you about the Baker Act and whether or not we can stop the hospital, if your loved one's out of hospital, from transferring your loved one to a Baker Act facility. And the simple answer to that is no, because the Baker Act is a statute that allows the state of Florida to take custody of somebody. So when your loved one has been Baker Acted, they have, for all intents and purposes, become a ward of the state of Florida. What that means is your right, your ability to make decisions for them, even if you have a healthcare proxy, has been terminated. You can no longer make decisions for them. It also means your loved one, whether or not they're an adult or a minor, they can no longer make their own decisions about their own healthcare. That's terminated too, which is why if you've watched any of my videos, I'm pretty adamant about the fact that you need to fight to get your loved one out as soon as possible. Now, sometimes we're dealing with a situation where your loved one has been taken to a hospital. Perhaps there was an allegation of self-harm, or they did try to self-harm, and they get taken to a hospital for medical assistance to be cleared medically. Now, if the hospital does not have a behavioral health unit, their own Baker Act unit, they're going to transfer your loved one to a Baker Act facility. Now, here where we reside in Palm Beach County, our local hospital, which is Boca, they do not have a Baker Act facility, and they do Baker Act a fair amount of people. And what tends to happen is that once they've been Baker Acted and they've been medically cleared, they then get transferred across county lines about 25 miles down the road to a facility down in Broward County. And there's no way for me to stop that. There simply isn't. Because remember, the state's power is ultimate. It's the ultimate power. They have all the power, unlimited resources. I cannot stop them from transferring your loved one. Now, if you call us early enough and it looks like your loved one's going to be transferred, what we'll typically do is we will file the case against the hospital, because they're the ones that have initiated the Baker Act most of the time. And even if it was done by the police, they're the ones that are holding your loved one. And so I will initiate the case against them. Now, is it possible they will refrain from transferring your loved one? It is. And we do ask them not to transfer your loved one. But it's also possible that they're going to ignore us and transfer your loved one anyway. And so in that instance, if we file the case against the hospital and they transfer your loved one, then we'll have to file a second case. We don't typically charge for that. It's just part of what we do. It's twice as much work, but we're here to help you and get your loved one out. And that's the mission. And that's what we're going to do. But I cannot stop the transfer. My team cannot stop the transfer. This is the state in action, which is why if you wait and see what happens, sometimes that can lead to disastrous results. And I've seen it happen. So if your loved one has been detained at a hospital and you've been told they're going to be transferred, this is the time to do something. And just FYI, something to bear in mind, until they actually get inside the behavioral health unit at the hospital, or they get shipped to transferred to a Baker Act receiving facility, the 72-hour clock isn't ticking. So if they've spent a couple of days in the hospital, it doesn't count. It does not count. And that was one of the major changes they made to the Baker Act statute last year. So the time to fight is now. Don't wait. Don't wait and see if they're going to be transferred. Because if the facility says they're transferring them, yeah, they're probably going to transfer them. Anyway, I hope that answers the question about the transfer. I would love a thumbs up. Please subscribe to the channel, and I will see you in the next video. Take care. Bye-bye.